Decision podcasts by the New York Prosecutors Training Institute are made possible by VoicePods. Convert your text to voice at voicepods.com. Read this decision at NYPTI Law. www.nypti.org/law.
The People v. Elijah Foster-Bey. Decided March 31, 2020. Memorandum. The order of the Appellate Division should be affirmed. This case was argued with People v. Cadman-Williams, decided herewith, and, although the underlying facts of the respective matters are different, the analysis and the result are the same. In this case, defendant shot a New York City police officer twice in the leg in an incident that was described for the jury by the victim as well as another police officer eyewitness. Two more police witnesses, respectively, linked defendant to the gun and established that defendant admitted to having shot the subject police officer, albeit accidentally per his claim. In addition to that evidence, the people intended to link defendant to the gun not through a standard DNA analysis, which could not connect defendant to the gun, but through LCN and FST evidence. Defendant sought an order precluding that evidence, but the trial court denied that application without first holding a Frye hearing. Similar to Williams, defendant relied on a scholarly writing from Dr. Bruce Budell in contending that LCN space evidence had not been deemed generally acceptable in the relevant scientific community, and that OCME space was the only government facility employing that method for analysis of evidence to be used in a criminal prosecution. Further similar to Williams, defendant contended that the FST space had not been generally accepted within the scientific community inasmuch as it had not been validated by anything or anyone other than OCME. The motion court denied defendant's application in a terse ruling that relied on People v. Garcia and People v. Magnath. The Appellate Division followed suit 158 AD 3D 641 2D Department 2018. Our analysis tracks that set forth in Williams in that it was an abuse of discretion as a matter of law to admit LCN space and FST space evidence without first holding a Frye hearing, given defendants showing that there was uncertainty regarding whether such proof was generally accepted in the relevant scientific community at the time of the subject motion. We also conclude, however, that the error here was harmless in light of the eyewitness testimony as to the shooting and defendant's admission to his involvement in that incident. See generally People v. Crimmins. Order affirmed, in a memorandum. Judges Rivera, Stein, Fahy and Wilson concur. Chief Judge DeFiore concurs in result in an opinion in which Judges Garcia and Feynman concur. Decided March 31, 2020.
Decision podcasts by the New York Prosecutors Training Institute are made possible by VoicePods. Convert your text to voice at voicepods.com. Read this decision at NYPTI Law. www.nypti.org/law.